These are some frequently asked questions about the retroactivity of California statutes. First, is a statute presumed to operate retroactively? In California, as in most states, a statute is actually presumed to operate prospectively. How do California courts generally view applying a statute's provisions? For example, in Quarry versus Doe in 2012, the California Supreme Court explained that in construing statutes, there's a presumption against retroactive application unless the legislature plainly has directed otherwise by means of express language of retroactivity or other sources that provide a clear and unavoidable implication that the legislature intended retroactive application of the statute. What does state law provide regarding application of statutes? The California Civil Code, for example, includes a specific codification of the general principle. It provides in Section 3 that no part of this code is retroactive unless expressly so declared. How are statutes generally applied when creating new rules? As a court of appeal in California explained, the presumption against retroactivity applies with particular force to laws creating new obligations, imposing new duties, or exacting new penalties. This is from the case of In Re Marriage of Ruling in 1994. How has the state's high court explained retroactivity of statutes? The California Supreme Court has explained that the general rule in this state is that if the legislature clearly indicated its intent that an amendment to a statute is to be applied retroactively, then a court generally must honor that intent unless there's a constitutional objection to doing so. The presumption against statutory retroactivity has consistently been explained by reference to the unfairness of imposing new burdens on persons after the fact. Can a statute apply retroactively in this state? Yes. For example, the California Supreme Court in the Myers case said a statute's retroactivity is in the first instance a policy determination for the legislature and one to which courts defer absent some constitutional objection to retroactivity. They also said that the basic rule in California is that a statute may be applied retroactively only if it contains express language of retroactivity or if other sources provide a clear and unavoidable implication that the legislature intended retroactive application. What has the state's high court said about legislative intent on retroactivity? The Cal Supreme Court has made the statement that where a statute provides that it clarifies or declares existing law, it's obvious that such a provision is indicative of a legislative intent that the amendment applies to all existing causes of action from the date of its enactment. In accordance with the general rules of statutory construction, we must give effect to this intention unless there's some constitutional objection thereto. The Cal Supreme Court said this in the Western Security Bank case. What do state courts look for in the statutory language? California courts look to the text of the bill and legislative materials to determine whether the later enacted bill made a change in the law or whether the later enacted bill clarified existing law. Now, what happens if a court views the statutory language as clarifying existing law? If the bill represents a clarification of existing law, then the bill is applied in all instances, both retroactively and prospectively. What happens if a court views the statutory language as changing existing law? If the bill enacts a change in the law, then the court looks to determine whether the legislature intended for the law change to be applied retroactively. In this regard, the court basically asks, did the legislature make a clear intent to apply the amendment retroactively? Now, what are the three main points of guidance from California courts on retroactivity of state statutes? The three main points that provide guidance to lawmakers and bill drafters when attempting to make retroactive changes to California statutes are: one, did the legislature enact the change in law promptly after the adverse court decision? In most instances, the legislative change needs to be made within a few months of the court decision. Two, has the Supreme Court rendered a final decision? If yes, then the legislative enactment is most likely to be only prospective in application. And third, is there some amount of ambiguity in the statute that was amended? The courts are usually more inclined to allow a retroactive law change when an ambiguous statute was amended by the legislature. And finally, can the legislature declare their statutory changes are retroactive? The legislature does have the authority to retroactively declare that certain statutory changes can be applied retroactively, but only in certain specified instances. And the most important is that the California Supreme Court has not ruled on the statute in question. Otherwise, the legislature can only make a prospective change in the law.